May it please your lordships. I appear with Mr. Livingston for the appellant Ofsted. Mr. Siegel and Mr. Kirk appear for the respondent to the appeal, Mr. Hewston. Mr. Kirk and I appeared at first instance and also at the Employment Appeals Tribunal. I will refer to the parties as they were at first instance.
Oh, Mr. Kirk appeared in the first instance as well. Oh, sorry, Mr. Kirk.
Mr. Kirk.
Sorry, I thought you said Mr. Livingston. Yes.
Yes. Mr. Kirk appeared and I appeared.
Absolutely. Yeah.
Mr. Livingston and Mr. Siegel are new to the proceedings. Forgive me. I will refer to the parties as they were at first instance, as the claimant and the respondent. I will address you on grounds 1 and 2. Mr. Livingston will address you on ground 3, substitution. Mr. Siegel and I have discussed the timetable. On our side, we hope to finish at or before 12:30, sooner if we can. He hopes to finish by 3:30. I may need 10 minutes to respond to him after that.
Well, that sounds all very satisfactory. I like the bit about sooner if I can.
That is certainly my intention.
But that's very much dependent on us, I appreciate.
Before I turn to the specific grounds, I wanted to address two important overarching points. And those are what the Employment Tribunal found that the claimant did and what the Employment Tribunal found about whether the claimant thought that what he did was appropriate.
Okay, let me just write that down. The second one, what he found about what the claimant thought about whether it was appropriate, is that right?
Yes. So whether the claimant thought that what he did was appropriate, what the tribunal found about that.
Right. Just before you get going, so there's not one small point, which is slightly relevant to the hearing, perhaps more relevant to judgment writing. One or two more details about the school, the kind of school it is, and so forth, emerge from the background papers than either the ET or the EAT. I'm imagining that because of the importance of avoiding identification of certainly the pupil, but possibly also the school, we should be very anodyne in reference to the school and not saying it would enable it to be identified. Is that right?
Certainly on the appellant side, we don't see any need to make any reference to the sort of details that would identify the school.
Okay, well, carry on.
So turning to that first overarching point, what the tribunal found that the claimant did. So I do quite understand that this is a case in which anyone coming to it for the first time, when presented with the dismissal of a long-serving inspector, who, as my learned friends in paragraph 6 of their skeleton put it, brushed rainwater off a student's head and briefly put his hand on the child's shoulder, one's initial reaction may well be that that seems harsh. However, the description of the incident by my learned friends at paragraph 6 of their skeleton is not one which is based upon any specific finding of fact by the tribunal, and it misses a number of relevant elements. So it was not in...
Can we just be clear about this before we start on this exercise, which will certainly be helpful? So far as the unfair dismissal claim was concerned, it was not for the Employment Tribunal to make any findings about the incident itself. Its focus was on what the employer reasonably and after proper inquiry believed had happened. However, because of the wrongful dismissal, the judge did have to make findings of her own, it's not entirely clear that she appreciated the distinction, but we need to bear that dichotomy in mind when looking at her findings, don't we?
My Lord, yes, and as your Lordships are aware, we haven't brought before this appeal tribunal any challenge to the decision of the Employment Appeal Tribunal that the wrongful dismissal decision needs to go back to be determined at tribunal level again. But what I'm not quite in agreement with is the suggestion that in an unfair dismissal case there is no need, or there's never any need, to make findings about what actually happened, because it may be that a tribunal needs to make such findings in order to make the crucial findings about whether it was within the bound of reasonable responses for an employer to dismiss for a particular reason.
One of us is
Particularly
just as likely to be me in my advanced years as you, but surely this is very basic stuff, isn't it? Maybe I've overstated it, but surely in a case about whether an act of misconduct was done, or about what it consisted of, if that's the material distinction, the focus is on what the, for unfair dismissal purposes, what the employer reasonably finds was done.
Yes, I entirely agree that that's where the focus is. I'm just not sure that it's so absolute that there is never any need to make a finding of fact about what actually happened, even if it was just an unfair dismissal case. There can be disputes even at the tribunal level as to what actually happened, and that
maybe in some secondary way, and of course it can come in on one of the at the remedy stage. But let's. I just want to get that clear in my head. I don't think we need to have a theoretical argument about it. I'm more interested in the detailed points you're about to make about what the evidence shows and the tribunal found about that evidence.
Yes,
which I imagine is what you're about to do.
Yes. So it wasn't in dispute before the tribunal that the claimant was a stranger to the boy in question, that he was in a position of authority, that the touch was uninvited.
Well, hang on, let's just. He was in a position of authority in a sense. He wasn't in a position of authority over the boy in the sense that a teacher would be.
No.
He's a visitor to the school in an official capacity, admittedly, and it looks as though the children understood that inspectors might want to talk to them, although that isn't what was happening in this particular incident. But that's not authority, is it?
Well, I mean, let me put it in a different way. He's an important person.
Okay.
I recall as a child myself being told that the inspector was coming.
Yes. No,
the school is on a certain
electric that bit I agree about.
Edge.
But there might, and I'm not sure it really matters in this case. It's my fault for interrupting you, really. But there might, in certain circumstances, be a significant distinction between merely being an important person and being a person in a position of authority. But
yes,
it probably doesn't matter here. Yeah, and then you said that the
touch was uninvited.
Uninvited, yeah.
And that it wasn't required as part of any inspection task of the claimants on that day.
Yeah.
And all of those points, just for your note, they're all covered in evidence. And if I can ask you, your Lordships, to turn to the supplementary bundle and page 22.
Certainly, if you want us to. Speaking for myself, seems to me they are obviously the case. I'd be surprised if they're disputing. Supplementary 22.
Yes, Mr. Siegel's very helpfully whispering to me that that's all common ground. And
yes.
So those were all matters put to the claimant in cross-examination in which he accepted. The stranger, the position of authority, the uninvited, and not required.
Yeah.
Turning more importantly to the Employment Tribunal judgment, at paragraph 47, which is at page 140 of your Lordship's core bundle, it is noted by the Employment Tribunal that at the disciplinary hearing, what was not in dispute was that the touch was uninvited. It was a touch on the head and forehead, and on the face of the child. That's page 140, paragraph 47. And then at paragraph 70...
So sorry, what, I'm
140, paragraph 47.
Bit odd that, because those are not entirely consistent with what was alleged against him. The allegations varied about where on the body he was touched, whether he was rubbed, whether he was wiped. So I was a bit struck by this concession because it didn't correspond to the allegations made.
Well, Lord, at page 41 of the supplementary bundle, we have the allegation, which is helpfully set out in the dismissal letter, and it was the same allegation in the invitation to disciplinary letter, which we don't have in the bundle before your lordships.
So it's page 41
of the supplementary bundle, which is that on the 8th of October 2019, whilst you were on inspection, without consent or invitation, touched a student on their head and shoulder.
Yeah, but not the face.
Yeah. Because how's the face come in?
It just creeps in 47, doesn't it?
The finding at 47 is based. Now, this is from memory. I think that's what the claimant said during the disciplinary hearing. But I have the note of the disciplinary.
Well, your junior is doing exactly what a junior should.
I think it's if we look at supplementary bundle page 22, which is where I was taking you, your lordships, which was the oral evidence from the claimant. What was put to him was...
This is at the tribunal.
This is at the tribunal, so this is me, Respondent's counsel, asking, you touched his head and wiped his face, is at the top. And the claimant said yes, but I have...
Well, then he goes on to amplify, and he says, I said you looked wet through and wiped a raindrop off his forehead. So far, it's only come from... I mean, we can get into semantic points, but is the forehead part of the head, or was it part of the face?
Well, I was going to suggest, my lord, that my forehead, which goes on for a long, long way back, I think it was part of my face, but
yeah.
I mean, giving too much evidence here about my...
This is help. We needn't debate these points. The case isn't going to turn on what you call what he did, and we can debate whether face gives a slightly different impression. The way the judge has recorded it, it's a touch on the head and the forehead and on the face, which would, if you're reading it literally, would mean a part of the face other than the forehead, otherwise she'd be repeating herself.
The and does suggest that, my lord.
Yes.
Then at paragraph 73 of the tribunal judgment, which is page 145 of the core bundle, so 9 lines down, the judge says, I conclude that such an uninvited and unnecessary touch by an unknown adult to wipe away water from child's forehead would cause any reasonable person who saw such an interaction to feel unease. The unbidden touch by an adult of an adolescent and young child by a stranger in this day and age would be seen as not appropriate and might be considered to be a misuse of power which violates the child's rights.
Where's this? Sorry,
so this is in the middle of paragraph 73 on page 145.
My fault, I haven't quite got my head around the age of this child at the time.
So year 7, which is first year of secondary school, 12 years old. Then we look at paragraphs.
It's hard to see. It's a misuse of power. That's a very odd phrase.
I mean, there was certainly cross-examination to the effect, and indeed, at the appeal stage, the claimant was accepting that he was insufficiently took on board at the time the power differential between him as an inspector, an important person, and the child.
You mean the child would feel awkward about saying, "Don't do that"?
Yes, and that was the context in which those questions arose. The claimant was suggesting that the child had signalled somehow non-verbally that it was okay to do what the claimant was doing, and it was suggested and ultimately accepted by the claimant that it would be very difficult for a child in those circumstances.
Yes, I see. No, I was perhaps not understanding sufficiently the sense in which that phrase was used. Okay.
And then finally in this section, just at paragraph 75 over the page at 146, there's reference in the second line to the claimant being an inspector and a senior member of the respondent's staff, and in the circumstances the claimant should have been aware of the consequences of inappropriate touching. And then the tribunal goes on to describe it 2 lines further on as, it was not advocated that casual, intrusive social touch was appropriate. So it's not quite put in this way, I accept, but casual, intrusive social touch would appear to be the nature of the touch that the Employment Tribunal was considering. So that's what the tribunal found about what happened. Turning to what the claimant thought was appropriate, the claimant, despite knowing up to the point of dismissal, despite knowing of the view that was being taken of his actions, and he certainly knew about it by the time he was being disciplined for it, because he is told in no uncertain terms that this is a matter which could lead to his dismissal. He gave the impression to his employer that he saw his actions as having been appropriate, and he didn't satisfy the respondent that he wouldn't do this or something like this again. Now again, in the cross-examination of the claimant, and this is the agreed note in supplementary bundle, page 23, a third of the way down that page, there was reference to a document submitted by the claimant on the 24th of October 2019. So that was prior to the disciplinary hearing. A document which stated that the touch was wholly appropriate to offer positive support to a young person in a caring and yet professional way. So going down that page, the claimant was asked specifically about the positive support and the wholly appropriate comment. He didn't deny that this was how he had expressed himself at the time, and indeed it was a written document from him.
So these are between the hole punches? Between
the hole punches. And perhaps going down to, you say it was wholly appropriate, towards the bottom of the page. And then over the page, just at the top of the next page, supplementary bundle page 24, again it was put that during the investigation meeting, the claimant said, "I don't think it was inappropriate," and repeated, "I don't think it was inappropriate in any way. Your position at the time," it was put to him by me, "your position at the time was that it was not inappropriate." And he accepted that that's what's written, so that's what's recorded in the record of the investigatory.
Yes, when it says C's counsel, that's presumably you, it should be R's counsel again.
Yes, that's me again. I would have been grateful for such an intervention from Mr. Kirk, but it seems unlikely that it would have happened.
I should say actually as well, these seem to be rather impressive notes, so whoever took them, so that somebody else was in a
I
position
believe
to...
that was my instructing solicitor, so she's sitting.
Well, I mean, I wasn't there, I can't say they're accurate, but they seem well written, and the fact they've been agreed by the other side is a tribute to somebody. Right.
And then, just finally on these, I understand that I have only a certain amount of weight here, but at the bottom of that same page, when it was put to the claimant that within the internal process, he was not saying that he wouldn't do it again. His response was merely that he wasn't saying that he would do it again.
No, but to be fair, he said explicitly on the previous page, would I do it again? No. And he gives a reason why.
My Lord, yes, but what he's being asked about at the bottom of page 24 is what he said during the process which led up to the decision that was made.
Are you sure that's right?
That's what he's being asked about at the bottom of
Oh, I
page
see.
24.
No, you're quite right. I see. Thank you.
And then we have the comment which the tribunal make a finding about, which is at core bundle, paragraph 48, page 140, which cites what the claimant said at the disciplinary interview. And that is in the part in italics. To say I would not do it again would suggest I'm guilty of acting inappropriately. I feel that the gestion of care for a child and engagement, I still feel that it was not a crime and needed to come to this point. It does not fall within the definition of gross misconduct. Having gone through all this and the stress, I can say that I would not do it again. That is not suggesting I'm guilty. Does it make sense? The tribunal also at paragraph 69, page 144, making reference here to the appeal stage, Mr. Simmons being the appeal decision maker. Paragraph 69 at the bottom of page 144 says, having heard the evidence of Mr. Simmons' test and in examination, I am satisfied that his decision was first and foremost based upon the decision that the claimant could not be relied upon to exercise clear-sighted professional judgment in the future. And then going back to paragraph 73, and I've already taken your lordships to 73 in a different part, but just the third line, the inspector is expected to exemplify the highest standards. And then at the end of that paragraph, 4 lines before the end, the claimant touched the child and did not see his actions as inappropriate. That's a finding by the tribunal. And this was the reason that caused the respondent to conclude that there was a fundamental loss of trust and confidence. And finally, on the tribunal's findings here, at page 146, tribunal paragraph 79, third line down, the claimant throughout the disciplinary hearing and for much of the appeal hearing maintained that his actions were seeking to show his compassion and care to a child in the school environment, while ignoring the fact that his role on an inspection was not to demonstrate that he, as an inspector, cared. So those were the findings of the tribunal as to the question of appropriateness, the claimant's view as to whether it was appropriate.
Yes, thank you.
My learned friends, in their skeleton, seek to make what I suggest is an entirely wrong related point, and it's in 2 places, paragraphs 29 and 97.1. if I take you to the first, Your Lordship, to the first example at paragraph 29, which is at page 47, where some significance is placed on the view that the LADO, the local authority designated officer, and 3 members of the Employment Appeal Tribunal had not thought that dismissal was appropriate in light of the information that they had before them. What that argument, which is, as I say, is repeated at paragraph 97.1, serves to do is to reinforce that the people who saw and heard all of the evidence, and in particular who saw and heard the claimant respond to the allegations against him. So in the case of the dismissing manager and the appeal manager, those that made the decision that he should be dismissed and that it be upheld. And in the case of the employment judge, who determined that the dismissal was within the band of reasonable responses, those people who had all of the evidence, they found against the claimant. And the employment judge, or it is the employment judge that we're concerned with, did that having seen all of the documentation relating to the internal process. There's 900
Well, perhaps the
pages.
point I made, I absolutely get your point. That the focus must be on what the decision makers, the original decision makers, both the decision makers on behalf of the employer, both at the initial stage and the appeal stage, what they reasonably thought on the material before them. I'm not sure what's added by referring to the fact that the Employment Tribunal, who had seen more material, employment judge who had seen more material, came to the same view. I'd have thought that's strictly irrelevant, isn't it? If she did come to the same view.
The tribunal, I think, does have to make findings of fact about what information was in front of the decision makers. And that, certainly in part, has been the subject of some of those paragraphs that I've taken Your Lordships to concerning what was said at the disciplinary interview and what was put forward in the investigation interview. But the Employment Tribunal, the Employment Judge's decision is the one under scrutiny here, of course. And the Employment Judge saw all of the documentation relating to the internal process. The Employment Appeal Tribunal didn't. The LADO certainly didn't. The Employment Judge heard the evidence of the respondents' witnesses as to why they came to the conclusion.
Oh, that's not a matter, yes.
The Employment Appeal Tribunal didn't, of course.
Yes, I have that.
And the Employment Judge heard the evidence of the respondents' witnesses as to why they considered that the claimant's actions, in the light of his attitude towards those actions, made dismissal a reasonable sanction. And the Employment Judge had seen the claimant's evidence. Now, I take Your Lordship's point in relation to findings of fact as to what he did on the day, but in relation to what the claimant's attitude had been during the internal process towards what he had done, the Employment Judge was able to see and hear the claimant's evidence at the tribunal about those things.
Yes, but it's first not what his attitude was, what attitude he had manifested to the decision makers. And as far as that's concerned, we have that because we have, again, very full records of the disciplinary interview and the appeal.
Yes, I accept that that's the right way to put it. And the Employment Judge also had seen the evidence of the claimant's witnesses as to what was and wasn't known to be inappropriate conduct, and as to the difficulty...
Known by whom?
Forgive me?
Known by whom?
By co-workers. So there was a suggestion, I'll find the specific passage in my skeleton argument. My lord.
Sorry, I didn't mean to take you off your point.
No, I should have the answer more quickly, but I don't. There was a specific witness called on the part of the claimant, to whom I put, might be easier for me to find it in the supplementary bundle actually.
Yes.
It's just the very page 29 of the supplementary bundle. Rosemary Chapman, who was witness called on behalf of the claimant colleague.
Yes.
It was put that based on your knowledge at the time for a stranger to touch a child of 12 on the face without that child initiating or inviting the conduct, that's clearly inappropriate unless the context requires it. I'd want to know more about the context, but on the face of it, it sounds possibly not appropriate. I'm not
Going
going
very far, is it?
So that, but there was also evidence, and this came from the trade union side, as to the difficulty of actually having a workable no-touch policy. Because there was quite a furore after this decision was made, in which the union were saying, well, we have to now have a policy. There were then deliberations between the union and and Ofsted.
Yes.
And in the end, by consent, there was no policy adopted because it's not possible to have one.
It doesn't. That's neutral, though, isn't it? On the point being made, there may be good reasons why there isn't a policy, namely that it all depends on the circumstances. But if that is the fact, that there is no policy, it all depends on the circumstances, it means that any particular person who does something believing it's unexceptionable can't be said to be that they either knew or ought to have known that it was wrong. It's simply a matter of their judgment.
Well, it must be left to the professional judgment of
Yes.
the individual. But that is precisely the focus internally of the respondent's actions in this case. Whether
Well, I see that. Sorry to be just have a debate with you about it. But if he made, let's assume for the sake of argument, a professional misjudgment in acting as he did, that's very different from breaking a departing from a clear instruction. And it's hard, depending on the circumstances, it might not be misconduct at all. Plenty of acts of professional misjudgment aren't misconduct. And if it is misconduct, it's of a much less serious character than breaking a rule. Isn't that the area we're in?
My Lord, I think the answer is it depends on the professional misjudgment. I mean, yes, there are examples of professional misjudgment which perhaps wouldn't lead to a disciplinary process at all. There are then examples of professional misjudgment, I'm thinking in the healthcare sector, which could lead to an obvious situation in which someone couldn't continue in employment. But if the professional misjudgment is inappropriately touching a child, I mean, we're going to come to this in perhaps greater depth, but the idea that you should not inappropriately touch a child doesn't need to be written down in a policy. The Employment Appeals Tribunal...
Yeah, but it's all in the word inappropriate. There's a problem about the word inappropriate anyway, because we all know it's used as a euphemism for a completely different kind of touching.
Yes.
But
and it's not
aiming off
suggested
that, it's
as-
difficult to find another. With that caveat, let's go on using the word inappropriate touching. But the whole point is, what is inappropriate is a matter of professional misjudgment. In the bad sense, inappropriate touching could never be said to be professional misjudgment. That's a completely different thing. But inappropriate touching of the kind we're concerned with here, if it is just a matter of judgment, whether it's the right thing to do in a given situation and he gets it wrong, why is that misconduct?
Well, it depends on the particular action, and it also depends on his view as to what he has done. And that's where his perspective on it during the internal process became such an important part of the decision to
Well,
dismiss.
I see that. Do you mind me just testing these points with you? But suppose he never doesn't think he even now doesn't think it was wrong. Suppose that's the case. And the employer thinks, well, it was wrong. I don't agree with your judgment.
Yes.
From my point of view, it's a misjudgment. But we all agree that it's, as it were, a matter of professional judgment. And he says, well, I still don't think what I did was wrong, but now I know you think it was wrong and you're my boss. I won't do it again. That's a perfectly respectable attitude, and one that an employer oughtn't to
I
worry about too much, is it?
two points in response. One is that as we saw from the tribunal's finding as to what the claimant said at the disciplinary interview, he wasn't actually saying that. What he was saying is, I wouldn't do it again because of having gone through all of this, meaning the process.
Yeah, that I understand.
He's not saying, I'm not going to do it again because you've told me I shouldn't do
He
it.
clearly thought he was in a bit of a catch-22. He didn't want to say that he thought it was wrong because, frankly, he hadn't thought it was wrong. If he thought it was wrong, he wouldn't have done it. And he might not. You might say, "Oh well, we wouldn't hold it against you if you acknowledged that it was, if you acknowledge now that it was wrong, even if you thought it was right at the time." But that's a pretty subtle distinction to have to make in the course of an oral cross-examination, so to speak. You can easily see why, in human terms, you would take the line he did, and also, it doesn't really matter, does it, if he said, "I won't do it again."
Well, the second point to make is that this is a case in which the employer dismissed him, having lost trust and confidence in his professional judgment, and dismissed him because it didn't have confidence that it could send him out on his own to do inspections in the
Yes,
future.
but I'm worried about this. Trust me, there's plenty of case law about this, which of course you'll be familiar with. Employers can't just say, "I've lost trust and confidence in you." It may be true, it may not be true, but the fact is you can't dismiss someone because you've lost confidence in them unless they have done something sufficiently serious to cause you to lose trust and confidence. If they lost trust and confidence in him when they shouldn't have, it's still an unfair dismissal.
But if someone does something like this, and their employer takes them to task for it, and they go to a disciplinary process, and they say, "I realise that what I did wasn't best practice, it wasn't professional, I shouldn't have done it. I've reflected on it, and I won't do it again." And that, my lord, is different from the scenario that you just put to me, which is simply, you don't like it, I understand, therefore I won't do it again. But this is a professional who's being trusted by his employer to go out into the workplace. If he says, "I've reflected on it and I won't do it again, I realise that what I did was wrong," then you could trust that person in the future. Because it's not just, will this person wipe rainwater off a child's forehead, face, touch him on the shoulder. There are a whole range of different things that could happen in this environment in which inspectors are being sent into, in schools and care homes and residential homes and so forth. And an employer such as Ofsted has to have a very high level of trust in the professional judgment of the person who's going to do it. And what the claimant was indicating to them was no more than, I haven't enjoyed being put through this disciplinary process, and therefore I would never do that thing again.
It's a bit more than that, to be fair. I mean, he said that he didn't know about Miss Gaffar's views about this, and once he'd known about those, he wouldn't do it again, because he realised it was disapproved of. So it's not just the fact that he'd been hauled over the coals.
My lord, he did say that, that's absolutely
Both
right.
those
But he also says, I'm not going to say that it was inappropriate because that would make me sound as if I was guilty. So, and there was a sense, this was covered in cross-examination of the claimant, in which over the internal processes, all the way up to the appeal stage, he went backwards and forwards in terms of what he said and the degree to which he accepted that there was any validity to any criticism of his actions at all.
Yeah, so he defended himself. Which is,
Yeah.
that's the dilemma that he was in, isn't it? he was defending himself against a charge of inappropriate behaviour. And he would say, without any clear statement of what it was about it that made it inappropriate. Because the standards that were being relied on, I have not detected exactly what the standards are that were said to have made it inappropriate. That seems to me to be, at least arguably, his position. So, well, I don't really know until Ms. Gaffar says there's this policy. I don't really know what it is that I'm supposed to not do, or why I'm not supposed to do it.
Well, my Lord, I will come to the standards because that is a specific ground when I get there.
Yeah.
Lord, I think you were.
No, that was very sensitive of you, but I've moved on. Anyway, if far as I had a point, it'll come in later.
So I was just listening. Lord, I will come back to your
Yes,
point. I'd rather deal with it.
Take it at the
Thank
time
you.
it arises, please.
Those are the advantages that the employment judge had over the Employment Appeals Tribunal. The Lado, who it's suggested by learned friends, that an initial expression upon giving an initial response to a report of the incident itself, the Lado didn't have any benefit of any investigation, didn't know what the claimant's attitude towards anything was, and was merely giving a basic response. That is irrelevant to the question of whether there was a fair dismissal. What happened at the Employment Appeals Tribunal was, putting it very bluntly, that the Appeal Tribunal fell for the very eloquent and clearly extremely effective submissions made by Mr. Kirk, who succeeded in doing what we're all told that we shouldn't do, which is to re-argue the substantive case on appeal. And he was able to do so with reference to only a selection of the material before the Employment Tribunal, which was in the supplementary bundle of materials that were before the Employment Appeals Tribunal. So those were my overarching points, and I have covered some of the ground in the grounds as well, so I'll be able to skip some of these. But turning to ground one, which the headline on ground one is whether the Employment Appeals Tribunal erred in its approach to whether the sanction of dismissal couldn't be within the band of reasonable responses. So, of course, the basic law is known to us all, but there's no harm in starting with Section 98 of the Employment Rights Act because it is the touchstone. So it's correctly referred to at paragraph 21 of the Employment Appeals Tribunal judgment, the bottom of page 85. There's no dispute now against the tribunal's finding that the reason for the dismissal was conduct. So the question for the tribunal, Section 98.4, is the dismissal fair or unfair, having regard to the reason shown by the employer, depends on whether in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating it as sufficient reason for dismissing the employee, and shall be determined in accordance with equity and the substantial merits of the case. The tribunal made reference to it, the Employment Appeals Tribunal, of course everyone gets right, and also gets right the next part, which is the band of reasonable responses test. The Employment Appeals Tribunal specifically noted at paragraph 69 of its decision that the Employment Tribunal's self-direction in relation to that was correct, albeit that I think I have to note that the Employment Appeals Tribunal said it was correct as far as it went. I don't know what as far as it went meant or means, but it's clearly not praise for the manner in which the Employment Tribunal correctly set out its self-direction. The test for the tribunal didn't involve any one critical question. An unfair dismissal case in general does not turn on one procedural matter or one substantive matter. It's about looking at all the circumstances. Ground 1.1, which is headlined Wrong Question / Inadequate Reasoning, is that we say that the Employment Tribunal's error is in its paragraph 92, which is at page 76 of your Lordship's core bundle, with reference to there not being a clear through line of reasoning. What's said is that the failure of a clear through line of reasoning is on that question. The question appears to refer to the previous paragraph. I think I may have given you the wrong page number. It's the right paragraph, which is paragraph 92, but it's page 103. Forgive me. So at 103, paragraph 92, secondly, there's respectively not a clear through line of reasoning on that question. So the question, I think we need to look at the previous paragraph. The question seems to be whether the choice of sanction was within the band of reasonable responses.
Hang on 1 second. Sorry, I was reading the wrong paragraph for some absurd reason. You may be right. But you don't want to say exactly what the question was.
No.
That line of reasoning on that question, and specifically as to whether, so that's refining what the real question was,
Yeah.
it's in the band of reasonable officers for them to consider that in the absence of a guidance document, he should have appreciated that his particular conduct was as grave as they considered it to be. That's
Yes.
the question.
Well, that's the specific one. I just think that to identify what that question means, I think the only place we could find it is in paragraph 91. And the only thing it could be is whether the choice of sanction was within the band of reasonable responses. Certainly, it makes sense.
All right, but I
then
mean,
that
I
this is
think
a
that's
specific-
the big question, and then they say how that big
Yes.
question applies specifically to the issue in this case. Yeah, okay.
And on the page before, at paragraphs 88 to 89, the appeal tribunal had identified correctly that it shouldn't interfere with the tribunal's finding that dismissal was within the band of reasonable responses unless the tribunal reasoning betrayed some principled error of law. However, we say that the EAT then overturned the tribunal's decision without identifying what this principled error of law was. Going back to 92, and the question, Lord, that you just, the specific question that you read out, what is said at the end is whether it was within the band of reasonable response for the dismissing appeal officer to consider that notwithstanding there was no guidance document on the question of physical contact or touch, the claimant should have appreciated at the time of the incident that his particular conduct was as grave as they both considered it to be. So the tribunal is being criticised for not having a clear through line of reasoning in relation to that matter. Now, shortly I'll, at ground 1.2, address your lordships on the question of the tribunal's approach to the level of appreciation of the claimant. But setting that aside for a moment, I say that the appeal tribunal were considering the wrong question. A tribunal doesn't need to ask itself whether it was within the band of reasonable responses for Ofsted managers to have found that the claimant should have appreciated at the time of the incident that his particular conduct was as grave as the dismissing and appeal officers considered it to be. That's far too specific a question. And it's not a requirement for a tribunal determining whether or not a dismissal is fair. This tribunal, turning to its decision at page 146, paragraph 77, this tribunal determined that at the time that the respondent took the decision to dismiss the claimant, the respondent had conducted a fair and reasonable investigation which founded their reasonable belief that the claimant's actions amounted to gross misconduct, and that was the reason for his dismissal. And then over the page at 147, in what because of an unfortunate numbering error within the tribunal's judgment, is now the second paragraph 71 on page 147. It says, this is a case in which I conclude that the claimant's dismissal was fair and reasonable in all of the circumstances, including taking into account the size and administrative resources of the respondent. The respondent has demonstrated they had a genuine belief that the claimant was guilty of misconduct, having conducted as much investigation into the matter as was reasonable. In the circumstances, to give the respondent reasonable grounds to find that belief. That's what a tribunal has to do in this sort of case. Having done those things, the only requirement of the tribunal was to find whether dismissal was a sanction within the band of reasonable responses. And the tribunal went on to consider that it was. It's at both paragraph 59, but I can take you, because we're on the page, 147, to the second paragraph 73. The respondent considered all of the circumstances of the case, and notwithstanding the effect of the dismissal on the claimant's ability to work as an inspector in the future, the sanction of dismissal fell within the range of reasonable responses that a reasonable employer could take. That's what a tribunal has to do. The appeal tribunal...
We'll just pause there. Of course it's what they have to do. But they can't be broad brush. They have got to apply those tests to the particular circumstances of the particular case. And that's the bit that the EAT said they didn't do.
Well, I'll come on to, I agree, Lord, but I'll come on to that. But that's what the tribunal did. The appeal tribunal, which substituted its judgment for the employment tribunal, didn't do those things. So there's no express finding in the appeal tribunal's judgment that dismissal was outside the band of reasonable responses. Now, returning to the point, Lord, that you just made, which is about how they get there, the presence or clarity of a specific rule is, of course, a relevant consideration in that exercise, a relevant circumstance. And the tribunal made findings in relation to that. Paragraph 65 at page 144. Mr. Simmons has confirmed that the respondent did not have and was not intending to introduce a no-touch policy, which led to the finding at page 145.
Hang on one second, sorry.
Forgive me.
Sorry, what was the reference to Mr. Simmons' evidence?
As paragraph 65, page 144.
Yep.
Then the finding in the conclusion section at paragraph 71, this is the first paragraph 71, at page 145, last sentence. In this case, there is no no-touch policy, and the respondent does not consider that a policy was required. But there are policies, and Lord, this is where I'm returning to your matter in relation to the codes and framework. So paragraph 42, page 139, the judge makes reference to both the Civil Service Code and the Social Care Inspection Framework, which set out standards of behaviour.
Sorry, again, just give me the page reference for where
139.
149.
139, my lord.
Thank you, yes.
Bottom of 139,
Yep.
paragraph 42.
Yep.
And then over to paragraph 43 at the top of page 140, 140.
Yes.
So set out standards of behaviour, in particular in relation to integrity, and then refers to the need to take account of ethical standards. Now, the tribunal hasn't specifically identified which of those codes this quote comes from. It comes from the Social Care Inspection Framework, and it's set out under the expectations of inspectors are that they must uphold and demonstrate Ofsted values at all times, carry out their work with integrity, treating all those that they meet with courtesy, respect, and sensitivity, take on all reasonable steps to prevent undue anxiety, minimise stress for those being inspected, act in the best interest and well-being of service users, prioritising the safeguarding of children at all times. Now, all of these matters are set out in the dismissal letter, which is in the supplementary bundle at page 43.
These are extraordinarily high level. They don't tell you how to behave in any particular circumstance. They're all matters involving judgment.
Excuse me. Well, my lord, they do say that you have to treat everyone that you meet with courtesy, respect, and sensitivity.
Well, we all ought to do that.
But I mean, not every employee in every workplace does do that, or the employment tribunals would be empty.
But this doesn't help. Oh, okay. Can you keep going? Okay, keep going.
So those specific factors were set out in the dismissal letter. They are standards with which the tribunal considered that paragraph 44 that the claimant was familiar with, and the tribunal also found at paragraph 79 that he was aware of the rules and the guidance.
Which rules of guidance are being referred to there?
This is at 146.
No, I see. But I see I've noted the phrase before in my reading. I just wasn't sure which rules and guidance were being referred to.
The only rules and guidance that had been referred to prior to that are the ones at paragraphs 42 to 43.
Are they not issued by the respondent, are they?
Well, the Civil Service Code is not. The social care. I don't know who issues the social care common inspection framework, but I would presume that it is not just covering Ofsted. Central government, yes.
Yes.
Sorry, I made a blunder in noting the location of the dismissal letter. Could you give me that reference again?
The dismissal letter is in the supplementary bundle at page 41.
41, I've got 143.
And the specific reference to this social care inspection framework and all those matters recounted by the Employment Tribunal is at page 43 of the supplementary bundle. So supplementary 41 at page 43.
But just running down as far as we can what the judge had in mind when saying the claimant was aware of the rules and guidance issued by the respondent. Your initial answer, which I understand, was, well, the only other rules and guidance referred to previously in the decision are 42 and 43. Those are not literally, in fact, however, as you've accepted, issued by the respondent. So either it was a slip and the judge meant the Civil Service Code and the SCIF, or she's referring to some other rules and guidance which she doesn't specify. Is that a fair summary?
It's accurate, but I would suggest that it could only be the ones that she's actually referred to 30 paragraphs before. Sorry, my lord, I'm getting a note. It's in relation to the answer to the question that was posed. I think it's just to correct something that I had said about the framework document.
Yes, thank you.
It is an Ofsted document.
Oh, I see.
Yeah.
Forgive me.
What I've struggled with in reading the papers is to identify which of these many different standards are said to have been breached. Now, it doesn't help to say that you've always got to act in a way that's professional, when the allegation is that you acted unprofessionally in an unspecified way. There's reference here to the need to carry out work with integrity, but I don't think he's accused of lacking integrity in the normal sense of the word. So I've struggled so far to identify what it was that either the employer or the Employment Tribunal judge thought was breached by way of a standard.
My lord, I think the answer must be at page 43 of the supplementary bundle in the dismissal letter under the heading Allegation 2, which is that your actions were inappropriate and contrary to the Ofsted core values, professional standards, and the Civil Service Code.
Sorry, just give me that.
Yes, well, that's the allegation, but normally in such a context, you'd want as clearly the appellant, the respondent sought more detail on what particulars
I think,
and the particulars are not very particular.
the particulars are not very detailed or particularized, but the specific passages of the code and framework that are being referred to are set out at the bullet points on page 43.
I see
and
that, but if I was him, I'd say, well, what steps did I fail to take to minimise stress?
Well, at the bottom of page 43, Lloyd, I think the answer is found there, which is that you stated that you felt your decision to brush rain from a boy's forehead was a caring act, and you felt this was a professional and appropriate. You've referred to your actions as caring, promoting engagement, and being paternalistic. You appeared not to recognise that inspectors do not hold a paternalistic role. And then over the page, in the second paragraph of page 44, I concluded that your response failed to recognise that you were a stranger in a position of authority and power. You took it upon yourself to make unnecessary physical contact in a way that could potentially have been seen as intimidating and unprofessional. You should no acknowledgement that your actions led to a referral to the LADO and were now part of a complaint from the school which should have been avoided. And it goes on.
Where does intimidating come from? Where does intimidating come from?
Could potentially have been seen as intimidating. That's a judgment of the person.
It must mean could reasonably, anything could be seen as. The question is whether objectively anyone would have felt intimidated by what had occurred.
I think the question at this point is whether the claimant reflected on whether his actions could potentially have been seen as intimidating. And this does go to his attitude towards what he did, which, as your lordships will have seen, is quite a significant part of the dismissal letter and the decision to dismiss and the tribunal's findings as to the decision to dismiss.
I mean, a puzzle about the structure of this letter. I mean, one sees these highly formalistic templates before, but clearly we understand what the allegation is about what he did. There's some points about whether it's exactly how it's formulated, whether the reference to face is appropriate, but we know all that, and you've helpfully reminded of this. Allegations 2, 3, and 4 are not really separate allegations. There's a single allegation. This is what you did. These are the reasons why you say they justify, that action justifies dismissal. It's not a very, it's a rather odd way of structuring it, but I no doubt that's the way they're told to do it. But what we're really after here is why is what you did sufficiently serious misconduct to justify dismissal? And simply to say it's unprofessional, it doesn't display integrity, it includes stress, doesn't really address the question of how serious it is. It's trying to fit it into a rather inappropriate formula, high-level formula. But in the real world, you ought to be saying, why was this such a bad thing to do, even if it was a misjudgment? And to try and fit it into the Civil Service Code seems to me a very formalistic way of doing it.
But what they're doing is focusing particularly here at allegations 2 and allegation 3, which is about the breach in trust and confidence. What they're doing is addressing the way in which the claimant came across to them when they were conducting the internal process, which coloured their view of the action itself and also added weight to their concern about what he had done.
Yes.
And they do set out...
As I do see, I suppose what I'm just questioning is whether making those common sense points is rather blurred by trying to fit it into these inappropriate, wrong word, but these unhelpful high-level labels.
It's rare to find
the real point here is not that it breaches this or that bit of the Civil Service Code. The real point is you did this. We think this was very serious.
And you don't.
And we think you don't realise how serious it was.
Yeah.
And this sort of blurring of snowfall of blurry words on it doesn't help analysis.
No. There aren't many beautiful dismissal letters in...
No, I know. It's easy for us to sit up here and complain. No doubt they would say, well, if we didn't do this, you'd be saying
if it was 5 lines long, then it wouldn't pass muster for other reasons.
All the same, sitting here in this court, I think it's not particularly helpful for us to have a lot of argument about in what sense it's unprofessional, in what sense it's doesn't show integrity.
I agree that it is simpler than the 5-6 page dismissal letter, because it's about what he did and whether he recognised the seriousness and whether he recognised the attitude that those who were managing him had towards it.
Yes, and then, dependent on those, whether what he did and there may be a point about this, and how serious, and whether he had insight, another word that's often used in this context, whether any failure of insight were taken together still a sufficient reason for dismissing him.
Yes, and this is where trust and confidence does, I think, legitimately come in, which is, can we trust you to go back out there on your own into the schools and care homes and so forth that we have to inspect?
Yes, but that feeds back into what it is that you might reasonably think he would do again, and how serious that is.
Well, fail to exercise his professional judgment. We're back round to that point again.
And this was, on any view, an episode which lasted, at most for a very few seconds, in wholly unforeseen circumstances. Rainstorm, pupils soaking wet, coming in unexpectedly. So it was a very human, immediate reaction to a very, very rare set of circumstances which are not going to be replicated in all probability. Isn't that relevant also? Just as part of one's consideration of what is ultimately a sort of jury-type question as to whether this is really a hanging offence, to put it crudely.
Well, my lord, it is relevant. There's no doubt that the nature of the act, the initial act, is relevant, as is the manner in which the claimant seems to have regarded it afterwards, including when it was very clear to him that others regarded it in a very different manner. However, it's not for this court to determine yea or nay whether this person should be dismissed for it, nor was it for the Employment Tribunal to decide that matter. It was about whether it was within the band of reasonable responses. And there are other factors as well which are relevant, which are, for example, those that I went through about the claimant being a stranger in a position of authority, the touch being uninvited, not required as part of an inspection task, and that he was an Ofsted inspector. The inspectors are supposed to be beyond the normal standard of behaviour. They're going in to criticise the way in which, potentially, I mean, they may be going into praise, but to criticise or praise the way in which these institutions operate. Those inspectors need to be behaving in a manner which is exemplary. And they need to be able to be trusted by Ofsted to go out and do that.
Well, except for all that, I mean, obviously, inspectors are in a very delicate and important position, and it's absolutely essential that their authority should be maintained and they shouldn't cross any boundaries. One of the problems here is that the boundaries are framed in terms which are so amorphous. It's really very difficult to do more than say, well, that all sounds absolutely fine in the kind of motherhood and apple pie way, but how does it really translate into an offence which can justify immediate dismissal?
And the answer, I think, I'm just going to repeat myself, is about not just the offence itself, but also the way in which the claimant presented his views about it. But just to attack head-on the idea that there must be a specific rule, the presence or clarity of a specific rule is a relevant circumstance. So in Malone Friend's skeleton, for example, at the top of page 45 of your bundle, in paragraph 18, is set out an extract from Brooks and Skinner, which makes it very clear that a relevant circumstance, but not the only relevant circumstance for a tribunal looking at a dismissal in these, of this sort, is whether there was a specific rule, whether that specific rule was clear. What Malone and Friends have sought to do in their skeleton argument is to elevate the question of whether the claimant knew at the time that he did it that he could be dismissed for inappropriately touching a child. They've sought to elevate it to what they call the critical question or the critical issue. And it's described in that way at paragraphs 24, 25 and 35 of Miller and Friends' skeleton argument. It's a question, I agree. It's not the question or the critical question. And even the Employment Appeals Tribunal don't suggest that it is the critical question, albeit that the way that they put it, that's the way the Appeal Tribunal puts it at paragraph 77, which is page 99 of your bundle, your Lordship's bundle, is that it is the question. What they should have said is that it is a question for the tribunal. And in any event, I say the tribunal did consider and did make findings about whether the claimant should have appreciated the potential consequences of his conduct. Paragraph 73 of the Employment Tribunal's decision, page 145, and I think I've probably read all of this out already. The inspector is expected to exemplify the highest standards. A reasonable person would have felt unease. In the circumstances, the claimant should have been aware of the consequences of inappropriate touching. And then, as I've also read out before, at paragraph 79, that the claimant was aware of the rules and guidance issued by the respondent. The Appeal Tribunal did note those paragraphs of the Tribunal's decision, not the specific points, but the paragraphs, at the EAT paragraph 94, which is at your Lordship's page 104. But the EAT then went on, we say wrongly, at paragraph 95, which is also at page 104, to say, at the end of 95, it appears to us that it was not open to the tribunal, in light of those facts, to conclude that the claimant had been placed on express fair notice that this particular conduct in this incident would attract the sanction of dismissal. So we said there's quite a lot wrong with that. Firstly, it is far too specific a requirement to place on an employer in the case of a person expected to exercise professional judgment, such as an Ofsted inspector. And in this regard, if I could take your Lordships to the authorities bundle and the case of RBS and Nosu Agwu eBay, which is starting at page 1414 of the authorities bundle. It's cited at paragraph 6.5 of our skeleton. In possibly not quite sufficient summary, the claimant was a bank manager. She had authorised an ID form used by someone who turned out to be a fraudster. We can see at page 23 of the authorities bundle, paragraph 26, the basic facts. She was at fault, that's at paragraph 27. And importantly, the Employment Tribunal found at paragraph 45, page 30 of your bundle. The Employment Tribunal found that she should have known better given her experience and seniority. The matter then came before the Employment Appeals Tribunal, who found...
Paragraph 45, did you say?
Paragraph 45.
Where does it say she should have known better?
Forgive me, I need my glasses for the tiny text at the bottom.
Doesn't appear to be. I mean, I'm not saying you're wrong, but I just didn't. I'm not sure you got the right reference.
Lord,
But I mean, it's up to you, of course.
Is,
Your submission's been so well judged beforehand, so that I will sure you are taking us to this in a way that will help us. But this is simply an EAT decision on a particular situation. Is there some point? What's the point of principle you're trying to get out of it? If it's merely illustrative and the facts are very different from the facts here, it doesn't really get us anywhere, does it?
well, the answer to that question, which I'm happy to answer because I don't seem to be able to answer the other question, where the known better is, which I'll come back to when I do find it, is at page 49.
So page
49.
Yep.
Paragraph 94.
Yes. Yeah, well, that's fine, but that's
Where we have
on the facts of that particular
unnecessary
case.
to specifically warn her of the consequences of what she already knew or should properly have known that the respondent would regard her breach of duty as serious.
Sorry. Speak for myself, I've got no difficulty with the proposition there will be cases where that is a sufficient answer. The question is whether this is one of them.
Well,
It's just on a point of detail. I think the finding of the Employment Tribunal was that he should have known, not that he did know. Is that right?
should have known,
Yes.
not that she did know.
No, in our case. This respondent should have, not that he did know. And then in the disciplinary process, I think the should have was explored, but I don't think there was a finding that he knew when he did the act that it was, to coin a phrase, inappropriate or even disapproved of.
Yes. I'm hesitating for a moment, my Lord, because I just wanted to find the specific paragraph in the Employment Tribunal's decision to answer your point, because
My point, or my Lord's point.
my Lord's point
Is right.
because I think it should have known, but
Yeah.
I
He knew the right.
I don't want to give you
There's a
the
finding of fact that he was aware of the rules and guidance. That's a finding of actual knowledge.
yes.
In '79,
That's not quite, that's not the one I'm looking for.
no.
Yes, it's 75, and it is should have. So 146, 75. The claimant was an inspector and a senior member of the respondent staff, and in the circumstances, the claimant should have been aware of the consequences of inappropriate touching.
Yes, and the circumstances, although they're not specified there, appear to be his knowledge of the standards.
Yes. Or perhaps more broadly than that. I mean,
Or perhaps-
everyone knows that you can't touch a child inappropriately. You don't need to have it written in a
No,
document.
But the question is what's inappropriate.
Yes.
No one knows that you can't ever touch a child under any circumstances, so it's all a question of what the appropriate circumstances are, and that was the debate.
Yes, I think it's just that maybe it's not just rooted in the Civil Service Code and in the framework document, but perhaps also in one's professional judgment
Yes.
beyond that.
Yeah. That's why I think they're really rather a red herring.
So, that was the first criticism that I had of what the Employment Appeal Tribunal said.
Yeah.
So they said that
You say far too specific was your...
not open to the tribunal to conclude that the claimant had been placed on express fair notice that this particular conduct in this incident would attract the sanction of dismissal. Far too specific a requirement on the employer. But my other criticism of the appeal tribunal is that the tribunal didn't actually reach that finding at all. So they didn't find that the claimant had been placed on express fair notice that this particular conduct in this incident would attract the sanction of dismissal. And they didn't have to. that's not a finding that a tribunal has to make when undertaking this exercise in relation to unfair dismissal. The tribunal make an observation at paragraph 37, page 138, that the decision as to sanction was that of the respondent alone to determine what is appropriate and reasonable. Now that isn't the same, and I don't seek to rely on it as suggesting that the respondent has an unfettered discretion as to whether something is serious enough for dismissal. It clearly always has to be within the band of reasonable responses. But it is right that the employer is entitled to make its decision as to what things that specific employer, in this case an inspectorate, considered to be serious. It's not for the Employment Tribunal or the Employment Appeal Tribunal to go in and say, well, that thing's actually not very serious. We make our decision as that.
I mean, this isn't a chestnut, but it really is. There is a risk that the band of reasonable responses test is treated as a perversity test, which Lord Justice Mummery says in terms it isn't.
Yeah.
It's simply a gloss on the actual word of the statute, which is, was it reasonable to dismiss for this reason? And it's far too late now to go back on the band of reasonable responses test, and I don't. But I think it'd be healthy sometimes for tribunals not always to direct themselves in terms of that, which really only matters at the margins. They should be saying, do I, who've been asked by Parliament to take this decision, think that it was reasonable to dismiss? Of course, I realise that there are sometimes two possible options. But the ultimate question is it reasonable?
Well, of course.
And the Employment Tribunal, apparently, though queried the route by which he got there, thought that it was. And the Employment Appeal Tribunal was satisfied that that was something that the Employment Tribunal should not have reached.
Yes, but the Appeal Tribunal appear to have reached that conclusion on the basis that they themselves didn't think it was reasonable, which is not their function.
Well, yes, I mean, there are cases which they obviously deciding whether something in the band of reasonable responses inevitably involves you forming your own view whether it was reasonable. We'll never. It's all a matter of degree, really.
But it's not the case. This isn't one of those cases where we have an Employment Tribunal decision where you don't really know what evidence they base their conclusion on or what their decisions are. I've set it out in our skeleton argument, pages 23 to 24 of the core bundle, paragraphs 9.1 to 9.11 set out all the evidence points, and I'm not going to improve on them by repeating them to your lordships now.
Yeah.
And the decisions that the tribunal reached are summarised at paragraphs 10.1 to 10.9 of my skeleton, at pages 24 to 25.
So, just give it, I've read them, but just give me the reference to my note now. And all the evidence at 9.4, did you say?
9.1 to 9.11, 23 to 24.
And the conclusion is at?
And the decisions are all at 10.1 to 10.9,
Yeah.
24 to 25. So what I say in summary in relation to ground 1.1 is that the Appeal Tribunal formulated a question that the Employment Tribunal did not need to address, which is that the claimant should have appreciated at the time of the incident that his particular conduct was as grave as the dismissing and appeal officers considered it to be. And then the Employment Appeal Tribunal criticised the Employment Tribunal for coming to a conclusion that the Employment Tribunal didn't come to at all, which is that the claimant was placed on express fair notice. And any decision of the Employment Appeal Tribunal which is based on those erroneous pillars cannot stand. Turning to ground 1.2, which takes us from an analysis of what the Appeal Tribunal did to the lack of a specific disciplinary rule itself. Now, there is some overlap and repetition here, but I hope it's worth it. A key question in the case from the outset has been the significance of there not being any no-touch policy. The tribunal made a finding about that. We've seen that, paragraph 71. The appeal tribunal at page 98, in its paragraph 74, accepts that there is conduct which need not have to be spelled out in advance to be grounds for dismissal. And at paragraph 87 at page 102, finds that there are some kinds of physical touch which fall into that category. No real surprise, I think, in either of those. Inappropriate touching of children can be gross misconduct, of course. But then at the end of the appeal tribunal's paragraph 87, and this is at page 102, is what we say is an error. The task for the Employment Tribunal when considering an unfair dismissal case is not to decide on any form of binary. Does the Claimant's Act fall into one category or another? The task for the tribunal is whether the employer's decision to dismiss for the Claimant's Act falls within the band of reasonable responses. Then we've got the appeal tribunal's criticism of the tribunal at paragraph 95, the express fair notice point, which I've just referred to. And we should look back. What the tribunal did find was that the claimant was or should have been aware of the consequences of inappropriate touching. Paragraph 75. The tribunal didn't find express fair notice, didn't need to make that finding. So if we look at the ACAS code to see, well, what are you actually required to do as a reasonable employer? The EAT helpfully at paragraph 30, page 87 to 88 of the bundle, set out the provisions of the current 2015 ACAS code. Rules and procedures for handling...
Sorry, where's the reference?
Sorry, page 87 of the bundle.
Thank you.
Over to 88. Paragraph 3030 of the EAT. Most of it's over at top of 88. The current ACAS code. Rules and procedures for handling disciplinary and grievance situations should be specific and clear. So I say, well, that's about the process, not about the list of acts that might lead to dismissal. That is covered at 24, which is that disciplinary rules should give examples of acts which the employer regards as acts of gross misconduct, rather than requiring that every potential act that might constitute gross misconduct is set out. And by its nature, you simply couldn't have a list that set out every single thing that could potentially be gross misconduct. The leading authority is Locke. That's within your Lordship's authorities bundle at page 75. The 1997 ACAS code was relevant at the time of that decision. And if we look at page 77 of Locke, 77 of the bundle, which is paragraph 11 of Locke, we there have the code of practice at that time. Employees should be made aware of the likely consequences of breaking rules, and in particular, they should be given a clear indication of the type of conduct which may warrant summary dismissal. At paragraph 22 of Locke, and this is where the red sidelining comes in, the Employment Appeals Tribunal held that it seems to us essential that employees should be given due warning of which types of misconduct will on a first breach lead to dismissal, entitled to know before they're dismissed what they may be in for if they break that particular rule. But it's about types of conduct. And the problem in Locke is shown at paragraph 19, which is a little bit further up the page, that in that case, that employer didn't spell out any lists at all, didn't give any types.
This is all rather beside the point, isn't it? Because this is nobody, I think, and I don't think the EAT was saying, well, I think the EAT was saying that if you had a no-touch policy, which you didn't, then that needs to be spelt out. Then it is an absolute rule, and you break it, you know where you are. If you don't have that, it's all a matter of judgment. And the question then is, should you realise that if you get it wrong, or what the employer thinks is wrong in this grey area of what touching is and isn't appropriate in particular circumstances, it's sufficiently reasonable to dismiss. That's the key question. Sorry, it is reasonable to dismiss. And that's the key question. That's what the EAT thought the key question was.
Well, and that, I think, then takes me on to ground 1.3, which is the relevance of the claimant's attitude towards the incident, because the Employment Appeals Tribunal didn't consider that that could be relevant. What was argued before both the Employment Tribunal and the Employment Appeals Tribunal was that the claimant was dismissed because of his conduct and his attitude towards that incident. And it's very clear from the wording of the dismissal letter. If I can take your lordships back to the supplementary bundle, page 40, and within that, page 46, it's clear there that the grave error of judgment you displayed in this case and your lack of contrition or recognition of any wrongdoing has led me to regretfully conclude that your actions and response to the challenge have destroyed the relationship of trust and confidence. The tribunal understood this, it's clear from paragraph 73 at page 145, where the tribunal find that the claimant touched the child and did not see his actions as inappropriate. But the Employment Appeal Tribunal quite clearly didn't like that. The analysis is at paragraphs 83 to 86, page 101 to 102. And I say that in particular the second sentence of paragraph 83 at page 101 of the core bundle, in which the appeal tribunal say, from its findings, accepting Ms. Fitzjohn's account in the dismissal letter, the tribunal find that this was also the conduct for which the claimant was dismissed, that being the touching incident itself. That's just wrong. That's not what the tribunal found. The tribunal.
Sorry, where are you in 18?
Sorry, I'm at the top of page 101.
Yes.
So paragraph 83, I'll read all of the first two sentences.
Yeah.
In the present case, the substantive conduct with which the claimant was charged was the touching incident itself.
So far, so good.
From its findings, accepting Ms. Fitzjohn's account in the dismissal letter, the tribunal found that this was also the conduct for which the claimant was dismissed. But the tribunal didn't find that. It found, at paragraph 73, page 145, that the claimant touched the child and did not see his actions as inappropriate, and it cited within its
But not
decisions,
seeing his actions appropriate isn't conduct. I don't think that's not what the EAT is saying. That clearly, the conduct for which he was dismissed was the touching. One of the reasons for finding that that conduct merited dismissal was that he didn't show sufficient contrition. I don't think that seems to me to be the correct analysis of the dismissal letter, or contrition and recognition. And I don't see that the EAT is saying anything different from that, is it?
Well, I think that it does, because what we've got at the beginning of paragraph 83 seems to form the basis of the Employment Appeal Tribunal's position, which, putting it in a nutshell, seems to be that if the initial conduct was not serious enough in itself to warrant gross misconduct dismissal, then whatever the attitude towards that conduct displayed by the claimant, it can't become serious enough to warrant unfair dismissal. And that's the position that the Employment Appeal Tribunal adopted, and I say that's wrong. I mean, I also say that it was serious enough to warrant summary dismissal in itself, but that wasn't the basis on which this employee was dismissed. He was dismissed very clearly from that lengthy dismissal letter and from the tribunal's findings because of the touching and his view as to the appropriateness of his actions. And the EAT at paragraph 40 does, which is page 90, it does correctly there summarise the submission that I was making. That this challenge failed to engage with the fact that an important part of the respondent's reason for dismissal related to the attitude to his conduct, which he displayed in the course of the disciplinary process, which undermined the ability of the respondent to place trust in him in the future. So that is what I was saying. By the time we get to page 99, at paragraph 78, the appeal tribunal say that my stance was that it was in fact not the respondent's position that the original incident was in and of itself conduct for which he could expect to be dismissed, but that the claimant had been dismissed because of his subsequent attitude to it. Now, that certainly wasn't an argument that I was intending to make. And it's clear that I didn't get my point across to the Employment Appeals Tribunal sufficiently clearly. But the reason for the dismissal was the claimant's error of judgment and his attitude. And there's no other way of reading the dismissal letter, or indeed the tribunal's decision. And in professional spheres such as this, where will he do it again is not only a necessary question, but perhaps the key question for an employer who is looking at an incident such as this. The attitude towards the conduct that has sparked the investigation is often key. I've already suggested to your lordships the matter which is set out again in my skeleton of paragraph 22, which I won't repeat, about the appeal tribunal failing to realise or recognise the distinction between someone saying, I wouldn't do it again because I didn't like being put through this process, and I won't do it again because I've reflected on it and I realise what you've said. Also in the skeleton at paragraph 28, page 33, we make the point that a tribunal needs to look at all the circumstances, and it's conducting an exercise which isn't like sentencing guidelines in a criminal case. It's not about getting to the right answer. And I've been trying to think of some theoretical examples which are neither offensive to the claimant or the respondent, but the best one I can think of is that if we took a workplace, for example, a law firm, lots of people coming in and out, some of them distressed or vulnerable people, an experienced solicitor hugs somebody in the workplace, a stranger, a new client. There's no hugging policy at the law firm. The recipient of the hug says he feels uncomfortable. There's an investigation. Now that could go two ways. What one might expect, hope for perhaps, is for the hugger to be told, don't do that again. The hugger said, moment of madness, I accept. Shouldn't have done it in the first place. I'll apologise, let me write to the client. Everyone gets on with their lives. But if the hugger says, well, I'm a hugger, people need hugs. Even in the office, people need hugs. Especially potential new clients, they need to be hugged. I'm being caring by going around hugging people. I don't see anything wrong with hugging new clients as they walk in the door. Well, then we might be into different territory. But these sort of theoretical examples are only of so much use. But that was the best one that I could come up with.
Yeah. Interesting example.
Paragraph 30 of the skeleton argument also gives a bit more detail, but the main point there is that the subsequent attitude isn't just relevant to the attitude itself, it also does colour an employer's view of the conduct itself, so of the attitude of the employee at the time of the incident. It can't be completely divorced from it. My learned friends in their skeleton make a couple of points which I don't think I've dealt with elsewhere on this ground. Paragraph 61, which is page 55 of the bundle, I don't think that this is right. What is suggested at paragraph 61 is that for conduct to amount to gross misconduct justifying summary dismissal, it must involve either deliberate wrongdoing or gross negligence. Of course, if it does involve deliberate wrongdoing or gross negligence, I can see that would be very likely to be unfair dismissal. But I think that that's pushing unfair dismissal and wrongful dismissal together. For the purposes of unfair dismissal, a contractual analysis like that isn't the right one to adopt. It's not necessary for conduct to amount to either deliberate wrongdoing or gross negligence for a tribunal to be able to find that a dismissal based on the conduct was within the band of reasonable responses. I accept that there might be different contentions in relation to wrongful dismissal. And paragraph 62 over the page...
So just to spell it out, you say it could be reasonable to dismiss someone who has done something quite not serious enough by itself to warrant dismissal, but where that betrays things about their attitude,
Yes.
Which are likely to affect their future performance.
Yes, and I don't
That's
think
whether they'll do that particular thing again or something different.
Yes, and I don't think that you would categorise that as gross negligence or deliberate wrongdoing. Wrongdoing maybe, but perhaps not deliberate wrongdoing. I don't think it...
Anyway, I see the point.
Okay. And then over the page at paragraph 62, page 56, there's a suggestion there that attitude can only be relevant to something that is definitely gross misconduct without the attitude. It's a bit like mitigation, or it's a sort of after the event consideration to see whether the penalty goes up or down, but you can't take attitude into account to make something gross misconduct when it wasn't in the first place. I don't see any reason why not.
Well, I mean, in a sense, one's making problems for oneself by setting up labels and then saying whether they apply or not. The question is not, is it gross misconduct? The question was it always the question, was it reasonable to dismiss for it?
Yes.
Wrongful dismissal might be different. I'm not sure it really would be. Yeah.
It is worth remembering that this section, all of ground one, is aimed at whether this was a substantively unfair dismissal. If this is a substantively unfair dismissal, then the respondent should have continued to employ someone in whom it hadn't just stated, we've lost trust and confidence in you, but it had gone through a process in which it had analysed its own reaction to the conduct and the attitude to the conduct, and concluded that it had lost trust and confidence, which is set out in the analysis, and the rationale is set out in the dismissal letter, particularly at page 45 of the supplementary bundle. That was ground one. I do want to make some sort of speed. Clearly my desired intention of finishing before 12:30 is not going to be achieved.
You have had, not a huge amount, but you've had a certain amount of questioning from us. Me, really.
Also need to give Mr. Livingston the time that he needs to address ground three. But ground two is a more straightforward matter which relates to procedural matters. So in summary, all of those matters were argued before the Employment Tribunal. All were matters that the Employment Tribunal took into consideration. And for the Appeal Tribunal to disagree with the Employment Tribunal as to whether procedural defects tipped the balance into unfairness is not identification of an error of law by the Appeal Tribunal, it's just a difference of opinion. and that's not the function of the appeal tribunal. So the mitigation point is the first one. The tribunal found at paragraph 58, which is page 142, that mitigation was considered and balanced by Ms. Fitzjohn against the finding that the claimant had made a grave error of judgment, and that were the claimant to remain as an SCRI, an inspector, she needed the highest level of trust and confidence in his being able to manage physical contact appropriately. She said the grave error of judgment displayed in this case and the lack of contrition and unrecognition of any wrongdoing has led me to regretfully conclude your actions and response to the challenge have destroyed the relationship of trust and confidence. The tribunal was aware of the length of service. It's in paragraph 1 of the tribunal's decision, page 132. We say that the tribunal does not need itself to make a determination in every case as to whether length of service meant that an employee should not have been dismissed. What the tribunal needs to do is to make a finding as to whether the respondent's approach to mitigation was within the band of reasonable responses. This tribunal determined that it was balanced against a finding that the claimant had made a grave error of judgment and that trust and confidence had been destroyed, but there isn't much room left there for further consideration by a tribunal of whether length of service should affect the reasonableness of that decision. And of course, length of service goes two ways. In a case where you're talking about lack of professionalism, you could take into account that someone who'd been an inspector for a very long period of time should have known better, as well as taking into account, of course, that length of service is a valid mitigation point. Consideration of the claimant's record also formed part of the appeal, and there's findings from the tribunal about that at paragraphs 63 to 64, pages 143 to 144. I've set out the law in relation to this matter in the skeleton at paragraph 33, page 34 of the bundle. I have nothing to add on that. My learned friends rely on paragraph 40 of the Brito-Babapule case. That's in their paragraph 67, page 57 of the bundle. Paragraph 40 of that case is at page 126 of the authorities bundle. So the case report starts at page 122, and that specific part is at paragraph 40. Very quick summary of the case. The offence was claiming sick pay whilst working elsewhere. What the Employment Tribunal had done wrong, quite clearly wrong, is at paragraph 28, page 125. What they'd said is that once gross misconduct is found, dismissal must always fall within the range of reasonable responses. At paragraph 38, at the end of it, is a discussion by Mr. Justice Langstaff as to whether the Employment Tribunal might have meant that it had taken into account the fact that the employer had made reference to mitigation in the dismissal letter. But at paragraph 39, Mr. Justice Langstaff points out that he has to go on what the Employment Tribunal actually said, which was a stark proposition of law, an argument of cause and consequence which admits of no exception. And then at paragraph 40, we can see it's at the end of paragraph 40. This general assessment necessarily includes a consideration of those matters that might mitigate. For that reason, we think that there's an error of direction to itself by the tribunal. That's as far as we can take that case. It's not, I suggest, authority for every tribunal in every unfair dismissal case having to individually consider the question of mitigation and whether the particular mitigation in this particular case rendered a dismissal outside the band of reasonable responses. The tribunal isn't abdicating its function to the employer, which is what it's accused of, if it reviews whether an employer has taken into account mitigating factors, and having done so, concludes that the employer's approach is within the range of reasonable responses. And this tribunal did that. Paragraph 59, page 142, records the tribunal's finding that the decision to dismiss was reached having considered all of the arguments and submissions from the claimant. And those included the mitigation points. And it concluded, the tribunal concluded, that it was within the band of reasonable responses. That's all they need to do. The next point in relation to procedure relates to documents. Now, any defects in terms of documents disclosed during an internal disciplinary process are exactly the sorts of matters that are considered with all the other relevant factors when a tribunal is determining whether in all the circumstances of the case a dismissal is within the band of reasonable responses. The tribunal considered the points made about documents. We can see that from paragraphs 36 to 37 and 40, and they came to a conclusion which was open to the tribunal at paragraph 77, which was that the respondent had conducted a fair and reasonable investigation. To elevate any consideration relating to any specific documents not disclosed to some form of absolute test is to go outside the band of reasonable responses test. At paragraph 37 of our skeleton, we've set out the Employment Appeals Tribunal's findings. I won't repeat that. But just going through these three documents, document 1 is the complaint from the school. It's at supplementary bundle pages 70 to 81.
Yes.
Most of it is completely irrelevant.
Yeah, we read it, yeah.
Paragraph 6, page 73, is the one relevant section. What my learned friends assert in their skeleton at paragraph 6 is that the other complaints in that document were generally more serious. Not a finding of the tribunal, not a finding of the Employment Appeals Tribunal. It's agreed that the claimant wasn't given the document before the dismissal. In the disciplinary hearing, the claimant was told of the relevant content in the complaint. Supplementary bundle, page 8 at the bottom, we've had a complaint from the school and they said that the child felt very uncomfortable. The school complaint was provided to the claimant at the appeal stage. He made no use of it whatsoever. And by that point, it is rather by the by, because he'd admitted that the touching had happened, as the tribunal had found.
Isn't, if I got this wrong, isn't the EAT's point that the complaint from the school and the fact that it contained so many other matters and had the particular tone that it did strongly reinforced a point that the claimant himself had made, which is the school there are incredibly at loggerheads with the inspectors, historically been at loggerheads with the inspectors, and these aren't the exact words used, that gives them an incentive to pick on some trivial incident and elevate it. And that's a point that I was making anyway. And look at this complaint, and you can see that is indeed exactly the context in which the complaint is made. Now, wouldn't that have been something that he could have done a lot with in the hearing?
Well, he did nothing with it at the appeal.
Well, I get that point.
And
I just wanted to make sure you understood the gravamen of what I understand to be AT's point.
yes, well, no, it isn't. I suggest it isn't a good point, because by the time the internal process is underway, if there was some sort of dispute about what the claimant had done or whether he'd done it at all, then all of these points might go on. But what's being looked at is, okay, this is what you did, you agree that you did it, and the focus is then on, do you understand the significance of what you did? The second document falls into the same category, really. That's the incident form with the note from the child. It's at page 3 of the supplementary bundle. Again, it's agreed the claimant wasn't given this document. The only significance is that it says that the child says, I didn't really feel that comfortable. The claimant has known all along that the respondent was saying that the school said that the student felt uncomfortable. The tribunal was aware of the document. It makes reference to it at paragraph 30. The tribunal was aware that the investigation report was which the claimant had was saying the claimant's behaviour could be interpreted by a child as uncomfortable and worrying. And again, the internal decision makers weren't making findings as to whether the claimant had touched the child or not. That was all admitted. The third document is the Lado communication. This is within your supplementary bundle 97 to 98.
Well, again, we've seen it, but if there's a particular reason to take us to it, please do.
I don't think it's necessary. Agreed, the claimant wasn't given the document prior to the dismissal. He was given this document by the time of the appeal. The claimant accepts this. There is at least a way of reading the Malone and Friends skeleton at paragraph 80 to suggest that the only thing that he was given before the appeal stage was the document 1, the complaint from the school, but it's accepted by Malone and Friends, to whom I'm grateful, that he was also given the Lado communication. The Lado's view, as I've already said, is irrelevant. The Lado, prior to investigation being undertaken, having not seen the claimant, his reaction, any of that, the Lado's view as to an appropriate potential penalty is neither here nor there. And the tribunal effectively found that at paragraph 37, page 138. We've set out at paragraph 38 of our skeleton why the appeal tribunal was wrong in relation to these documents. In summary, the appeal tribunal has failed to set out why the employment tribunal's approach was an error of law. Instead, it simply seems to have concluded that the tribunal was wrong because the appeal tribunal would have come to a different conclusion in relation to the documents. The last point, I'm not even sure if it is a point, is the one about exculpatory evidence.
It's not clear to me that that was part of the...
No, it's a remark in passing, I think. And the appeal tribunal...
Mr. Siegel, but he's not prepared to make any concessions, so you better deal with it.
Well, what's said at paragraph 100...
I'm happy to concede we're not going to win the appeal on that point. I think it's part of a package which demonstrates...
Well, all right, we mustn't take shortcut.
Well,
deal with it, but it's all in your skeleton.
It's not going to take me... Paragraph 107, page 107 to 108 of the bundle, it's a comment rather than a finding of an error of law. If it is a finding of an error of law, there are no sufficient reasons given as to why it's an error of law. What the EAT is saying is, well, this could have happened, but then the claimant could have raised it himself. It's the sort of thing that might warrant sending a message back to the Employment Tribunal and saying, under the Burns-Bark procedure, what did you mean by this, or can you answer that? But it's not going to warrant substituting judgments or even remission to a different employment tribunal. It is a non-point.
Yeah.
Those, apologies for the gallop through grind.
No, I think you got the weight of your submissions in the right place.
And then Mr. Livingston's going to address you in relation to the substitution point, which is grind 3.
Yes. Can I just ask before he does, which of you is going to address this on remission to a fresh tribunal? Or do you want to do that if it becomes relevant? Won't take long whenever you do it.
I think it might be best to do it if it becomes relevant, because it depends a little bit on what...
Well, let's do that.
Because we've got ground 1 and ground 2, there are the various...
Very strictly speaking, I think it should be a separate ground of appeal, but it's... well, effectively it is a separate ground of appeal, I see, yes. Okay, but, well, then you won't deal with it now, you will deal with it in submissions if you... My Lord's happy with that? Yeah.
So in written submissions...
Written after handing down, if it becomes relevant, as part of the consequential matters.
Yes, I think that would be the best way to deal with it, because there are
no need to say more.
Various different possibilities, including that it might be best to send it back to the same tribunal if, for example, ground 1 succeeds, but there was some element of ground 2 and procedure that didn't.
Let's see.
Yes. So I'm grateful, my Lords, and Mr. Livington's now going to address you on ground 3.
Yes, thank you.
May it please your lordships. So, even if you're against us on grounds 1 or 2, there is separate consideration in this case of whether the EAT erred in substituting a finding of unfair dismissal.
So effectively what you're saying is that if the errors of law which it says were made by the ET were made, it should have remitted and not decided it for itself.
Yes.
It's a Jaffrey point.
Exactly. And it may depend, your decision on this may depend on whether you find that grounds 1 or 2 or grounds 1 and 2 were errors of law, because...
Well, I think that's a very sensible concession, and I don't want to shut you up, but it's very much bound up with the submissions we've already heard, isn't it?
It is to an extent, although we would say that in this case, the narrowness of the situations in which an Employment Appeal Tribunal can substitute its decisions weren't fully recognised, and the reasoning why it was able to substitute its decision isn't clearly explained. The narrowness point, I don't think I need to go through in much detail. You were one of the judges in Jaffrey.
Yes, well, I think all of us have come across Jaffrey before.
Indeed. So the point essentially, and we've set out the law in our skeleton argument, there's no dispute about that, but the point essentially, of course, is that really the EAT can only answer the question if there is one answer.
Yeah.
If there's more than one answer, it has to send it back. It doesn't matter if it thinks it's in a very good position to decide it itself by this stage. That's not enough. And I think it is worth bearing in mind that although my learned friends cite, I think, a comment from your lordship in Jaffrey to the effect that 50% or so of Employment Appeal Tribunal decisions, only 50% or so are remitted.
No, it wasn't me who said that. I think it was Lord Justice Maurice Kay in the subsequent case. But
I'm grateful, but of course there is...
what I said was appeal tribunals in these circumstances should be robust.
Indeed.
To mitigate some of the unfortunate effects of Jaffrey.
Indeed, and there's of course no dispute about that, and we're of course content for that. There is some stepping back to be taken as to the types of cases in which they can be robust. I think one can think of different categorizations, and the peculiar nature of the fairness of dismissal is one of the types of cases which is fairly obviously within the province of an employment tribunal, we would say. And so we would say the type of case, of course, affects whether the EAT can substitute its decision. The band of reasonable responses, or as your lordship suggested, frankly the section 98.4 question of whether it's fair in all the circumstances is a very fact-heavy decision for an appellate tribunal to be making. So we say that the reasons given by the EAT in this case for substituting its judgment don't only give one outcome. And so it decides to quash the judgment that the dismissal was fair, and we see the basis for this at paragraph 97 of the EAT, page 104 to 105. And it starts at the bottom, well, we say the relevant part starts at the bottom of page 104. Given that this specific incident was not found to have raised a safeguarding issue, that the respondent did not claim and was not found to have a no-touch policy, and that it was not disputed that there was no policy or guidance given in training specifically on the subject of touch, had the tribunal applied the law to the particular fact found in this case, it would have been bound to conclude that it was not fair to dismiss the claimant, and he was not on fair notice that this conduct might attract that sanction. So we say that's 4 things that the EAT has said left an ET bound to find an unfair dismissal. One is the specific incident wasn't found to raise a safeguarding issue. Second is no-touch policy. Third is no policy or guidance given in training on the subject of touch. And fourth is that he was not on fair notice that the conduct might attract that sanction. Now we say those are 4 factors which an employment tribunal would of course have to take into account when deciding a dismissal is fair, but they do not answer the question. If one was presented with those 4 factors as admitted facts in the case, if an employment tribunal was presented with those 4 as admitted facts in the case, that would not be the end of the matter.
Well, why wouldn't it be the end? Why was not the EAT entitled to say, or right to say, that it would have been the end of the matter? What are you saying it leaves out?
Well, it leaves out questions like whether the claimant should have been aware that his conduct might lead to dismissal, So it says that he was not on fair notice. It doesn't say that his conduct,
So it leaves out.
whether the claimant should have been aware that his conduct might lead to
Yes, I
dismissal.
see.
And of course, the ET found.
Those are points they dealt with elsewhere, aren't they?
Well, the EAT don't make an explicit finding on that, and the
Yes, I
ET
see.
did find that the claimant should have been aware of the consequences of inappropriate touch. It doesn't specifically say that.
Okay.
It might be
So
just-
one is whether he should have been aware.
Others are mitigation offered on behalf of the employee, which way that goes. So that's
Well,
another-
mitigation only ever goes one way.
Well, length of service, in fact.
So whether he, well, that all goes into whether he should have been aware because he'd been there for so long.
Yes, indeed.
I imagine you're going to say his reaction to,
Yes, so
which is what Mr. Allen has been
his
emphasising.
attitude during the disciplinary
Attitude, yeah.
process, indeed.
Okay, so whether he should have been aware, incorporating length of service, his attitude, what else?
Whether it would be, in fact, be possible or reasonable for Ofsted to have a policy on touch, or whether that would be reasonable. It was agreed that it didn't, and Ofsted's position was that it couldn't.
Why would that have affected the fairness of the dismissal, given there wasn't one?
Well, I suppose the point it leaves is by saying that the fact that there's no touch policy contributes to there being unfair dismissal. It presupposes that this conduct could be covered in a specific policy. And
Well,
without
no.
introducing that-
No, it comes back to the point we looked at with Mr. Allen. It may well be that it's all too subtle and nuanced to have a absolute policy, in which case that's not a point in favour of the employer particularly, it's a neutral point. It just means that in a case of this kind, it all comes down to whether he should have been aware, which you have rightly identified as something which you've identified as something which you say should have been dealt with. I'm not sure this is a separate point.
I think that is largely right, although I think whether it's all too nuanced to have a policy is something which contributes to it, because if you say actually the employer could and should have had a policy on this, then it becomes an easier decision, I would say. But I appreciate it's not the strongest point on that. And then the final point is whether in fact the employer had lost trust and confidence in the claimant, as Mr. Allen has referred to earlier. We say that in most cases, but certainly in this type of case, that is a relevant matter.
Okay.
And so we say that taking all of those into account, there is at least some potential that an employment tribunal could conclude that dismissal is fair. That's obvious. And as Mr. Allen said, the EAT in this case, although substituting its opinion, its decision did not make a finding that dismissal was outside the range of reasonable response.
Yes, thank you. Is that where we are?
Yes, very and very briefly. Just give me 1 second. Yes, we say that, and I won't take you through these, but I'll give you the references because Mr. Allen's already taken you to the paragraphs. Is that we say the EAT itself says that there were questions that the Employment Tribunal should have asked itself, and those are particular questions for the Employment Tribunal. So the questions that the Employment Tribunal should have asked itself are at paragraphs 77 and 87 of the EAT decision, pages 99 and 102. I won't go to them unless you need me to at the moment.
No, but
Really the main thing is, should it have been obvious from the nature of the claimant's conduct, it was conduct for which he could expect to be dismissed. EAT specifically said those are questions the Employment Tribunal should have asked itself. It wasn't remitted to the Employment Tribunal for it to ask itself those questions. And we say that involves a factual assessment, which is something which the EAT is not in a position.
yes, it's an unusual feature, but I think you'll say logically it doesn't go anywhere, that the EAT, in fact, had lay members, and lay members with, it might be thought, fairly specific, useful qualifications in this area, whereas the employment judge didn't. But you say irrelevant. It is the EAT, it's not the ET.
Yes, if it's to be suggested that, and that goes back to the Jaffrey point, that it's not enough that the EAT is in as good a position to make a finding. It's got to be that there is only one finding. And just finally on this, and sorry, so we say that for the EAT to be in a position to answer the question themselves, you would have to come to the conclusion, we say, that it would have been impossible for an employment tribunal faced with those factors to lawfully reach a decision of fair dismissal. Not possible. Only if it's not possible can the EAT substitute.
I've got it, yeah.
And just finally, there is a point made by my learned friends at paragraphs 97 to 98 of their skeleton. I'm afraid, and I'm sure this is my fault, I don't understand it at the moment. It refers to a concession, an alleged concession made by Mr. Allen, which we're not clear about. So I think if that is elaborated on in its submissions,
You'll deal with it in reply. Yeah, I can't at the moment think what it is, but we'll find out.
Yes. So, my lords, unless there's anything I can address you on further.
No, thank you very much indeed. Yes, Mr. Siegel.
Yes,
Not much later than you expected to rise, so that's quite good.
Yes. Afternoon, my lords. We've set out in our skeleton a detailed rebuttal of the respondents' criticisms of the EAT judgment, which we commend as well reasoned and correct. In these oral submissions, I'll focus on the tribunal judgment. But I'll start, if I may, by referring to some of the authorities. If you could go to page 9 of the authorities bundle for convenience, that's within the Newbound case. Like my lord did, it's unfashionable, but I'm going to actually start with the statute. And indeed, my learned friend did the same.
So which tab did you say?
It's the first tab, and it's page 9 within the Newbound decision. I'll take you there because I'm going to continue within that decision. But at 57, right-hand column, you'll see the statutory provisions are set out. And it's all about the determination, as it's put by the tribunal, of whether the dismissal is fair or unfair. That's got to depend on whether the employer acted reasonably or unreasonably in treating the reason for dismissal sufficient for dismissal, and that shall be determined in accordance with equity and substantial merits of the case. So, my lord, I accept to some extent it's probably too late to row back from some of the long lines of cases glossing this statute, but it is critical to recall that the statute does require the tribunal to make a determination, and one that is in accordance with equity and the substantial merits of the case. And notwithstanding the band of reasonable responses gloss, that is to say, if some employers would have treated the reason as sufficient to dismiss, that may be sufficient even if the employment judge
Would reasonably have.
Correct, then that may be enough, even if the tribunal itself would not have applied that sanction. That's, as I take it, the gist of that long line of authority. But that...
and that's the point that Lord Justice Bean
yes, and
really making in this case.
Yes, and if one goes to the next page at paragraph 61, we would respectfully adopt Lord Justice Bean, with whom Lady Justice King and Sir Terence Everton agree, in saying that the band of reasonable responses has been a stock phrase, but it's not infinitely wide. You've got to remember the statute, which requires directs employment tribunals to decide the question in accordance with equity and the substantial merits. This provision indicates that in creating the statutory cause of action, Parliament did not intend the tribunal's consideration of a case of this kind to be a matter of procedural box ticking. Now that's obviously a very deprecatory phrase, but without, I hope, overstepping the mark, that is not far from what this employment judge did. Whilst in new bold, 2 short points. If we go to paragraph 42, which is a long paragraph beginning at the very bottom of page 6 and continuing on to page 7, you'll see there's a huge indented quote from the tribunal's judgment. And you'll note it was a significant part of that reasoning approved by the Court of Appeal that the claimant had not been trained on what in that case was in fact a written procedure, albeit newly introduced. So you see within the indented paragraph 46, second line, I was not satisfied that the claimant and his colleagues had been trained in its significance. That's the new policy, and about 7 lines further down, I was also not satisfied. Mr. Dennis had explained to the claimant that the failure to wear breathing apparatus would lead to disciplinary action, possibly dismissal. And if you go to paragraph 71 on, excuse me, on page 11, under the heading discussion, there's reference to that paragraph. And Lord Justice Bean says he regards it as containing certain findings of fact which he considers crucial, and little b, the claimant and his colleagues had not been trained in its significance. And in the present case, it's common ground that Mr. Hewston was not trained in any requirement around the use of touch, and indeed there was evidence before both the disciplinary and the tribunal to that effect. And then another short point on the same page, at paragraphs 76 to 77, the court makes comments which we say are germane to one of the grounds of appeal in this case about the duty to take into account long service without disciplinary record. Judge held that the claimant's 34 years of service of clean disciplinary record had not been given sufficient weight. Mr. Jones submits this was an error of law. The weight to be attached, he submits, is entirely a matter for the employers. They did take it into account, but there's a major point against it. They decided with his experience he should have known better. That's, by the way, I think that the phrase, having done a word search, should have known better is in this case. And the breach so serious that the record was irrelevant. Mr. Jones' submission, which found favour with the appeal tribunal, is an attempt to stretch the band of reasonable responses to an infinite width. In assessing the reasonableness of the decision to dismiss, length of service is not forbidden territory for the Employment Tribunal. The fact that Mr. Newbound was an employee of 34 years of service with a clean disciplinary record was a factor the judge was fully entitled to take into account. And note the final words, it would have been extraordinary if he had not done so. Now, how the judge takes it into account, what weight ultimately the judge gives it, that's a separate question. But that it should be taken into account should not be controversial. And in making that statutory determination, another statute has given tribunals some guidance. At 207, you don't have this in front of you, of the 92 Act, though it's referred to in several places. There's a provision that any part of a specified ACAS code of practice, which is relevant to any question arising in the proceedings, shall be taken into account in determining the question. Now, in this case, because we're talking about a conduct dismissal, the relevant code is the Code of Practice on Disciplinary and Grievance Procedures in 2015. Can I take you to that's the Authorities Bundle. It's the penultimate tab, page 131. Because this is from the leading practitioner's work on employment law, Harvey's, we say it is correctly stated in that highlighted passage that the ACAS Code of Practice has always attached importance to an employer making disciplinary rules clear to employees, including the likely results of breach. This applies generally, but it is stated at paragraph 24, that's of the code, that it is particularly important in relation to possible summary dismissal for gross misconduct. Now, one might say that all ACAS is doing there is formalising an obvious rule of natural justice, but in any event, by statute, tribunals must take that into account in a relevant case. You'll see that, of course, they go on to cite the Employment Appeals Tribunal's judgment in this case. What is perhaps worth noting is towards the bottom of that page, the editor's assessment of some of that, taking it from about 10 lines up, there's a line beginning EAT and a sentence beginning halfway through that line. There were obvious procedural gaps relating to non-disclosure of important evidence and the failure to take into account his service record that would probably have made the dismissal unfair anyway, but the key to the case was the reason for the dismissal. And a few lines down, on the key point of dismissal for the touching itself, the judgment accepts that there will be cases where touching is so wrong that any employee would realise it must not be done. To use the phrase that's been used before, should have known better. But this was not such a case, especially as it was accepted from the beginning that there were no actual safeguarding considerations. So when one uses the word inappropriate, by the way, one needs to tread a little carefully. Inappropriate touching and safeguarding cover, if not exactly the same territory, a very similar territory.
We've already made that point.
Yeah.
I think, Mr. Allen.
Short of such obvious cases, it will be potentially unfair for the employer to dismiss for acting in a way that has not been specified as being unacceptable to the employer as a ground and a ground for dismissal. It is doubly so in the case of summary dismissal for a one-off act. We respectfully say that is all well said. Another useful case is at page 75 of the same bundle. It's the case of Locke. I'm afraid I'm working electronically, so unless the tab's in at the beginning or the end, I don't know which tab number it is. But it's
Well, don't worry, my tabs are all strictly numbered anyway.
So this is
77, yep.
75 is the case at the beginning of the case. One just notes for brevity that within the head note, the third paragraph, the employer's disciplinary code set out a number of potential disciplinary offences and a range of possible sanctions. It did not specify, however, which offences would be regarded as gross misconduct justifying dismissal for breach, and then the first holding of the Employment Appeals Tribunal, the Industrial Tribunal's finding that the employers had acted reasonably in dismissing the applicant train conductor for a one-off act of misjudgment in dealing with a passenger travelling without a valid ticket was perverse, since the employee had never been told he would be dismissed for a one-off act of that sort. No reasonable tribunal properly directing itself could have concluded that dismissal was a fair penalty. Now, that case was a fortiori for the employer. Relevant offences had been set out in a disciplinary code, simply not categorised. This will lead to dismissal, this will not. And one sees that this is an example of an Employment Appeals Tribunal overturning a tribunal's decision that a dismissal was within the reasonable range of responses because the claimant had not been told and it was not obvious that the misconduct in question might lead to dismissal. That's, of course, what the Employment Appeals Tribunal did. In this case, you'll see other examples in the authorities. It is not an uncommon step for an Employment Appeals Tribunal to take. At 4, paragraph 4, on the next page, excuse me, towards the bottom in the indented type, at paragraph 27, the Tribunal said, this is rejected, this is not a question of mistake, it was a matter of judgment. Then next column, top of the page, he was alleged to have shown a lack of judgment, and then there's a paragraph 2 below, beginning, Mr. Hirani properly took into account.
This is just showing us examples of other cases, isn't it? I mean,
it is, but it's. I'm only, I hope, drawing on those parts of these examples where the parallels with the present case are stark. So there's a policy, you'll note, of courtesy towards customers, much as in this case there was a widely expressed policy of courtesy towards service users, etc. So we say that there are parallels in that, in this case, the employer had concerns about the claimant's professional judgment, and the only policy on which it claimed to rely told inspectors little more than they should, quote, carry out their work with integrity, treating all they meet with courtesy, respect, and sensitivity. And then on the points of more general significance, at paragraph 11 on the next page, you'll see the quote from the Code of Practice. It was then paragraph 8, now paragraph 24. Employees should be made of the likely consequences of breaking rules, and in particular, they should be given a clear indication of the type of conduct which may warrant summary dismissal. And at 15, I should say at the outset, this is a case where I've turned to my lay members for guidance. Next paragraph, it is their view, having regard to the standard laid down in the code, that the decision of the tribunal departs from the standards of sound industrial experience as put into practice. It is their view, with which I entirely agree, that no reasonable tribunal, properly directing itself, could have concluded that a one-off act of the sort referred to could justify a dismissal. And then at 19, we observe that nowhere have the employers spelt out the likely consequences for the employee of breaking rules other than in a general sense. In particular, they fail to give a clear indication.
Well, we were shown all this by Mr. Allen.
And then, well,
Right.
well, forgive me, I wasn't. 22, Mr. Allen took you to, I think.
Yes. And 19, but it doesn't matter.
But that to us is, my Lord asked me, as it were, for general principles rather than applications to specific facts.
Yes.
That is it. It seems to us essential employees should be given due warning of which types of conduct. Now notice, by the way, the phrase due warning, or as it was put as a shorthand, be on fair notice. There's two ways you can be given due warning, in a sense. Either it says so somewhere, or as a variant of that first, you are trained. You attend a session of training and you're told don't do this. Or you're on fair notice because it's obvious. If you punch a fellow employee on the nose without justification, no one has to have said that, though they often may in a disciplinary policy, that is gross misconduct and may well lead to your dismissal. So it's essential that employees should be given due warning of which types of misconduct will, on a first breach, lead to dismissal. Now note that again. My learned friend attempted, we will revisit, a wonderfully nuanced argument about an offence that isn't gross misconduct, but becomes one that justifies dismissal when coupled with the response during the disciplinary process, etc. It may apply in another case, we say it couldn't, but this isn't this case. This case is one where the employee was fairly and squarely accused and convicted of allegations of gross misconduct justifying summary dismissal. So they're entitled to know before they're dismissed what they may be in for if they break the rule. It seems to us no answer to say that there was a code, obviously A48 to this case, or what the union had said. It would that it would justify dismissal for gross misconduct. It's clear from paragraph 16 that any breach of any of those rules might have led to action short of dismissal. And finally, at 24, just on the question of what EATs or this.
Well, let's just read it.
Okay. It's the disposal.
Yeah.
And then possibly just have time for one further paragraph and one further authority. Page 104 in the judgment of Mr. Justice Belden, who then was in Brooks.
Yeah.
Addressing head-on a point that my learned friend raised this morning when he accused the Employment Appeals Tribunal of illegitimately elevating one question as being the only relevant question. Not at all. There are certain questions an employment tribunal must ask itself in certain types of case. Not only one question, we agree, but if one question that an employment tribunal must ask itself is not asked or answered, that is a clear error of law. This is what these were the words of Mr. Justice Belden. It seems this tribunal that whether or not an employer is justified in treating a particular matter of conduct as sufficient to justify a dismissal must include the question whether the employee knew in a particular case that his conduct would merit summary dismissal. As much conduct an employee will know will merit instant dismissal.
Well, again, we'll read to the end.
I'm grateful.
Yep.
My Lord, it's 1 o'clock. I don't know whether it's appropriate now.
Nothing else in Brooks. Very well. 2 o'clock.
Oh, well,